Good evening, ladies and gentlemen. It gives us immense pleasure to welcome everyone present here to the final round of arguments for the 26th DM Harish Memorial Government Law College International Moot Court Competition 2025. I am honored to welcome Honorable Judges of the Bombay High Court, Honorable Mr. Justice Chagla, Honorable Mr. Justice Khata, and Honorable Mr. Justice Pooliwala, who will be presiding over the final round of arguments this evening. I would like to request the honorable judges and finalists to commence with the final round of arguments. We look forward to a competitive and enthralling round.
Thank you, Mr. President, Your Excellencies, and may it please the Court. Today, I appear before you as the applicant, the Federal Republic of Indore. Over the course of the first 14 minutes, I will be addressing this Court on issues 1 and 3, concerning the validity of Alderon's execution and Indore's refusal to recognize the award, respectively. In the next 14 minutes, my co-agent will address this Court on issues 2 and 4, concerning sovereign immunity and sanctions, respectively. We respectfully reserve 2 minutes for rebuttal. Your Excellency, today's case concerns an award that validates a contract which exposes Indorian citizens' data to a foreign government. Your Excellency, the Indorian judiciary, which is the seat court, set aside the award on the grounds that it was inconsistent not just with the Indorian constitution, but also the non-derogable norms of international law, including privacy, dignity, and freedom. Yet, completely disregarding this, the Alderanian courts proceeded to enforce this annulled award. Your Excellencies, it is this impugned act of Alderon that is in challenge before the court today. Your Excellencies, we submit that Alderon's actions raise serious questions about the viability of the international arbitration process, as well as Indore's sovereign right to defend its own constitutional order. On this background, we have two broad submissions to make. On issue 1, we submit that Alderon, by enforcing a set-aside award, has violated the New York Convention. And on issue 3, that Indore, by refusing to recognize the award, has not violated the New York Convention. Your Excellencies, if there are no further questions, I'd like to proceed to my arguments on the first issue. Thank you. On the first issue, Your Excellencies, we submit that Alderon, by enforcing a set-aside award, has violated the New York Convention. And we say this principally for two reasons. Firstly, Alderon has violated Article 5(1)(e) of the New York Convention. This is because the moment that an award is set aside, it ceases to exist. The second reason, Your Excellencies, is that even if Alderanian courts were found to have discretion, they improperly exercised this discretion. Proceeding to my first ground, Your Excellencies, I invite you to page number 7 of the applicant's compendium. Page number 6, rather, Your Excellencies, when Your Excellencies are with me. Your Excellencies, Article 5(1)(e) has been extracted, and if I may quote, recognition and enforcement of the award may be refused where the award has been set aside by a competent authority of the country in which the award was made. Your Excellencies, I also refer you to the compromise, particularly page number 4 and paragraph number 10. Your Excellencies, this is the most moot problem. Page number 4, Your Excellency. Yes, Your Excellency. Just under para 10, there's a footnote number 1, if Your Excellencies will notice. And the third line reads, the seat was declared as Indore City. The moot problem, Your Excellency. Indeed, Your Excellency. This is page number 4 and footnote number 1 right at the bottom. No, Your Excellency, it is. Your Excellency? Indeed, Your Excellencies. Page number 4, footnote number 1, right at the bottom. Your Excellency, the third line makes it clear that Indore city was declared as a seat of arbitration. Now, what this means, Your Excellencies, is that Indorian courts have primary supervisory jurisdiction over all matters related to the challenge of the award. Soon after the project was declared unconstitutional, the Indorian Supreme Court set aside the award on the ground that it was inconsistent with both the Indorian constitution as well as non-derogable norms of privacy, dignity, and freedom. Now, Your Excellencies, the moment that an award is set aside, it ceases to exist. Your Excellencies, I refer you to page number 7 of the compendium. When Your Excellency?
Article 5 of the New York Convention sets out the grounds.
Indeed.
Which ground would you follow?
Your Excellencies, we submit that the respondents will seek to argue that Alderaan has not violated the New York Convention because they have not violated Article 5.1e. What Article 5.1e does is it suggests that once an award is set aside, it may not be enforced.
But as far as law courts are concerned, why did they set aside the award?
They set aside the award, Your Excellencies, because they felt that it condoned violations of the Indorian Constitution, particularly privacy, dignity, and freedom. Your Excellencies, if I may address this in greater detail under my submissions on issue 3, but I will briefly put it to you as the award granted damages on a contract which exposed the Indorian citizens' data to a foreign government. By doing so, they implicitly validated the underlying contract and thereby exposed it to an Indorian public policy violation. If that satisfies Your Excellency, I'd like to move on. Your Excellency, as I was suggesting, the moment that an award is set aside, it ceases to exist. And there is plenty of state practice to this effect. Particularly, page 7 of the compendium refers to a German Court of Appeals case. If I may quote paragraph number 5 from that case, an award is no longer binding when it has been set aside by a competent court or an appellate arbitral tribunal, even by a temporarily enforceable decision. Your Excellencies, in page 14 of the compendium, there is more extensive state practice suggesting that the moment that an award is set aside by a seat country, other courts will show deference to the seat jurisdiction's annulment. Now, Your Excellency, in page number 7 again, there's a case of Baker Marine, which brings out a very simple policy concern with allowing Alderanian courts to enforce a set-aside award. This is the concern of forum shopping. Today, Your Excellencies, Indore has annulled the award, Alderaan has enforced the award. If today the court upholds Alderaan's enforcement, then tomorrow claimants will have every incentive to go court by court until they find a court which finds that the award can be enforced. The seat jurisdiction's annulment will have no effect whatsoever. Your Excellency, we submit that the law of the seat confers the lex arbitrae to the broader scheme. The substantive law of the agreement, which was chosen as the law of the United States here, is only relevant insofar as the arbitral tribunal has to decide as to the rights and liabilities of the underlying contract. Thus, all matters, including setting aside, Your Excellencies, would be governed by the lex arbitrae, which is the Indorian Arbitration Act. Now, proceeding, Your Excellencies, to my second ground, the respondents might argue, relying on the text of Article 5.1e, that it uses the word may and not shall. Recognition may be refused and not shall be refused. Now, I will address that even if Alderanian courts did have discretion, they improperly exercised this discretion. Your Excellency, the standard to enforce an annulled award is that the enforcement court must feel that a failure to enforce the award would be repugnant to fundamental notions of what is decent and just in the enforcement state. We submit that Alderaan, even taken at their own standard, will not meet the essentials of the standard. Let us briefly go back to the facts of this case, Your Excellency. The arrangement was for a national data security claim. This was in the context of terrorist threats that the Andorian government was facing. Now, as a part of this contract, by the virtue of the Freedom Act of 2001 of Tatooine, Andorian citizens' data is exposed to a foreign government's monitoring. Now, by any standards of international law, Your Excellencies, this breaches privacy, dignity, and freedom of Andorian citizens. Now, on this very basis alone, Alderon should have decided that this award, if enforced, would condone a violation of the Andorian constitution. But nevertheless, completely disregarding this, they enforce the award, suggesting that damages must nevertheless be paid. We take issue with this act and submit that even taken at their best standard, Your Excellencies, Alderaanian courts could not have enforced the award. If I may be of no further assistance on this issue, I'd like to proceed to my submissions on the third issue.
As far as Skynet is concerned, can it not claim damages for breach, even if the contract was against the right of privacy, especially since 30% of the work was already done and executed?
Your Excellency, we thank you for bringing up that point. And our answer is no. Skynet cannot claim damages for breach. This is because no valid damages claim can arise from a contract that violates the fundamental public policy of Endor. To that, we will refer you to the case of World Duty Free v. Kenya. Now, this is a case decided by the ICSID Tribunal, where a contract was obtained by fraud and bribery, and thereby infringed on the public policy of Kenya. Finally, the court held that even though damages and expropriation claims were raised, they could not be validly enforced because the root of the contract itself offends the public policy of the enforcement state. We submit that by parity of reasoning, even in this case, the court must not enforce or give validation to Alderon's enforcement. Proceeding, Your Excellencies, to our submissions on issue 3, we submit that Endor has validly invoked the public policy exception under Article 5(2)(b). I refer you to page 54 of the compendium, Your Excellencies. Now here, Article 5(2)(b) has been extracted, and I quote, recognition and enforcement of an arbitral award rather, may also be refused where it would be contrary to the public policy of that country. Now, naturally, that country here refers to Endor. Now, Your Excellencies, this award was blatantly in violation of Andorian public policy because it infringed on privacy, dignity, and freedom of Andorian citizens. Now, secondly, the question that arises is, does the award violate public policy in truth? The respondents might argue that all that the award does is grant damages for expropriation, and thus it must not violate public policy. However, Your Excellencies, we submit that it is settled practice that where damages claims arise from an underlying contract that offends the public policy of the state concerned, no valid damages or expropriation claims can arise from that contract. We submit, Your Excellencies, that this is recognized in several cases, such as the case of World Duty Free v. Kenya, the case of Soleimani v. Soleimani, decided by the English Court of Appeals, as well as Plamo Corporations, which is another investment case, Your Excellencies. Now, proceeding, Your Excellencies, if I can assist you any further on this issue, I'd be happy to. Now, finally, Your Excellencies, we'd like to refer you to the case of BCB Belize. This is extracted in page number 58 of our compendium. Now, Your Excellencies, I refer you to paragraph number 61 of this case, if Your Excellencies are with me. This case essentially concerned a matter where the government had entered into a contract whereby the contract violated the principles of parliamentary sovereignty as well as the principle of separation of powers of the government of Belize. Now, the Supreme Court, when it was confronted with an award that granted damages on the basis of this contract, held that no such award can be enforced even if it only grants damages because it infringes on the fundamental principles of the Belize Constitution. Your Excellencies, I refer you and would like to conclude my speech by referring you to paragraph number 61. The fourth line says, if this court ordered enforcement of this award, we would effectively be rewarding corporate citizens for participating in the violation of the fundamental law of Belize and punishing the state for refusing to acquiesce in the violation. On this basis, Your Excellencies, we submit that the International Court of Justice in this case must uphold the same treatment. That concludes our submissions, unless I can be of any further assistance. Thank you, Your Excellencies.
Am I audible, Your Excellencies? Thank you. A very good evening, Your Excellencies. Over the course of the next 14 minutes, I will be continuing the applicant submissions for the second and fourth issues before the court today. I will first address this court on the second issue concerning the execution of the assets of the Sovereign Gold Fund of Endor, where we submit that such an execution is inconsistent with both the FSIA, which is the domestic law of Endor, and also customary international law. I will then address this court on the fourth issue concerning Tatooine's alleged use of force through its imposition of economic sanctions, where we submit that such sanctions are indeed violative of specifically Article 2.4 of the UN Charter, which is a treaty law on use of force. Proceeding first to the second issue, Your Excellency. Your Excellencies, the second issue essentially involves a question of whether a private creditor may be allowed to attach the assets of a state, irrespective of how integral and important these assets are for the well-being of that state and its peoples. Now, that is precisely the case in the present dispute, Your Excellency. After Andorian courts refused to enforce the arbitral award, given its inconsistency with public policy, Skynet decided to go forum shopping. It arrived at the courts of Alderon, whose legal machinery it used to attach the funds of the Sovereign Gold Fund of Endor, a fund meant explicitly for the benefit and welfare of the Andorian state and its citizens. Now, Your Excellency, it is this action of the respondent which is in question today. We submit that it violates customary international law and also the FSI. In this regard, we have two primary submissions, Your Excellency. First, we submit that this court has the competent jurisdiction to try this dispute, contrary to what the respondents today might claim. And secondly, that customary international law and FSIA both grant a restrictive immunity to central bank property, and therefore the Sovereign Gold Fund of Endor is immune under both international law and the FSIA. Proceeding first to the preliminary point on jurisdiction, Your Excellencies. The respondents will contend, as they have in their written submissions, that the New York Convention governs both enforcement and execution, and therefore Article 3 of the New York Convention, which mandates application of domestic law, would require that only the FSIA be applied to the exclusion of customary international law. Your Excellency, we submit that this submission fails to note the distinction between enforcement and execution as two distinct parts of the post-award process. Now, Your Excellency, while enforcement is a process through which an arbitral award is given formal legal effect, execution is the process through which the reliefs envisaged by the award are actually effective. And therefore, it involves the question, as it does in the present case, of which assets can actually be attached by courts. Therefore, Your Excellency, we submit that because the New York Convention does not mention execution at all, there's not even one reference to the same in the convention, that therefore customary international law is equally applicable to the present dispute. Your Excellencies, if the court is satisfied with respect to its jurisdiction, we will move to our substantive submissions. Your Excellency, proceeding to our second substantive submission under this issue, we submit that both FSI and customary international law envisage a restrictive immunity for central bank property. Now, Your Excellencies would note that clarification 16 of the compromise provides that the Bank of Endor, which is the owner of these funds, is also the central bank of Endor. Therefore, the rules which apply are the rules which govern central bank immunity. Now, in this regard, Your Excellencies, interestingly, you would note that both the FSIA and CIL, which is customary international law, codify the same identical standard for central bank immunity. If I may invite your attention to first page 21 of the applicant's compendium. On page 21, we have extracted the case of Banque Compofina versus Banco de Guatemala, which is a case which lays down the standard for central bank immunity under the FSI. If Your Excellencies are with me, page 21. Your Excellencies would note the second paragraph in this case gives us a standard for central bank property. It states that funds held for a central bank's own account are funds used or held in connection with central banking activities, as distinguished from funds used solely to finance the commercial transactions of other entities or of foreign states. Now, this is the standard under the FSI. If I may.
Endor contends that the Sovereign Gold Fund is used for sovereign activity.
Indeed.
Correct?
Indeed.
As the purpose of the fund is only to finance infrastructure and communication projects,
Indeed.
which are not unique to a sovereign state and can be done by somebody else. How can this be said to be a sovereign activity.
Indeed. Your Excellency, this brings us to our next submission, where we submit that the functions being discharged by the Central Bank of Indore are indeed sovereign. Now, as your Excellencies would note, under this particular case, the
What those functions are, as far as the central bank is concerned, it's fine. But ultimately, your sovereign gold fund is going to be used for these kinds of activities, finance, infrastructure, or communication projects, etc. These are not sovereign subjects. These are not subjects dealing with the sovereignty of a country. So therefore, why do you say that the sovereign gold fund is the gold fund is a sovereign activity or sovereign authority?
Your Excellency, we would submit that the standard which we seek to apply under in this present dispute does not concern itself with the purpose of the sovereign gold fund, but is rather a question of capacity, which is in what capacity is a central bank acting in owning and managing these funds. To further provide clarity on the standard, if I may invite your attention to page 40 of the applicant's compendium. Now, Your Excellency, here we have extracted Professor Wirth's article, which includes a survey of state practice and articulates the standard that prevails under customary international law. Now, on page 41, the second sentence, which is in bolded, Your Excellencies, if Your Excellencies are with me, it also articulates an identical standard wherein it states that the correct test under Article 21(1)(c), which is a treaty provision which deals with central bank immunity, is whether they are being used for discharge of central bank functions. So, returning to Your Excellency's question, we submit that in the present case, they are indeed being used for central banking functions, Your Excellency.
When you say central banking functions, if it is used for financing infrastructure and communication projects,
Indeed.
as my brother judge just mentioned, then wouldn't it really be serving a public purpose rather than a sovereign function?
Indeed. Your Excellency, with respect to whether the exact management of these funds, which corresponds to whether or not it's a central banking function, we would invite your attention to page 20 of the compendium. Now, Your Excellency, the phrase central banking functions includes many different functions which a central bank routinely undertakes. Now, Professor Koch's seminal work, which documents the various central banking functions that can be provided immunity, provides, and this is the second last paragraph on that page, if Your Excellencies are with me, that the performance of general banking and agency services for its government is indeed a function of a central bank. Now, in the present case, as Your Excellencies correctly highlighted, the sovereign gold fund of Indore is essentially executing projects for the development of critical national infrastructure. Now, given that these projects are, as you said, inherently of a public nature, we submit that in providing banking and agency services for the sovereign gold fund of Indore, the Central Bank of Indore is indeed acting in its capacity as a central bank and is discharging a central banking function. Now, Your Excellencies, if I may be of no further assistance on the second issue, I would proceed to my submissions on the fourth issue. Your Excellencies, proceeding to the fourth issue, we submit that tattooing sanctions which have been imposed in the state of Indore are firstly violative of Article 2(4), and secondly, that the respondent cannot raise a defense of countermeasures in the present case. With
But first, can economic sanctions be considered as a use of force, first of all?
That brings me to my first submission, Your Excellency. We submit that it can. And if I may invite your attention in this regard to page 100 of the compendium. Your Excellency's Article 2(4) of the Charter is extracted on page 100. Excuse me, page 86. Yeah. On page 86, Your Excellency's Article 2(4) is extracted. It provides that all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state, or in any other manner consistent with the purposes of the UN. Now, Your Excellencies would note, therefore, that there's two ingredients which the applicant must satisfy to succeed on this issue. First, as Your Excellencies highlighted, that economic sanctions constitute use of force, and second, that they have somehow violated the purposes of the UN Charter. We submit that both of these ingredients are satisfied. Coming to the first, Your Excellency, with respect to the use of force, if I may invite your attention to the very next page. The first General Assembly resolution, which has been extracted there, General Assembly Resolution 2625. Now, Your Excellencies, the extracted part of that resolution, and you would note interestingly that the language is identical to the language of Article 2.4. It states and it recalls the duty of states to refrain in their international relations from military, political, economic, or any other form of coercion aimed against political independence or territorial integrity of another state. Your Excellency, we therefore submit that this resolution, dated almost 3 decades after the codification of Article 2.4, reflects an implicit wish of states to expand the scope of Article 2.4 in recognition of the fact that state actions which can endanger territorial integrity or political independence are not restricted only to armed force. And this is increasingly a political and economic reality, Your Excellencies. Given the increasing prevalence of both economic sanctions as well as an increasingly globalized world, the harm that economic sanctions can cause to a state is well documented. And therefore, we submit that Resolution 2625 reflects this intention of states and acknowledges this development in international relations. Furthermore, Your Excellencies, we submit, and this brings me to our next reason that we submit that economic sanctions constitute use of force, which is that this court is empowered to undertake an evolutionary model of interpretation. What this means, and this court has articulated it precisely in the Namibia opinion as well as in the Tunisia and Morocco dispute. What this means is that courts can, the ICJ, can interpret international instruments in a dynamic fashion and subject to the development of international relations. Relying on my previous submission, Your Excellency, given both the increasing prevalence of economic sanctions, as is evidenced by the sanctions imposed on Russia, Iran, and many other states, and secondly, the increasingly globalized state of both global commerce and national economies, we submit that economic sanctions should indeed be interpreted in an evolutionary manner to be included under Article 2.4. We believe this is further reinforced by the fact that the UN Charter is a living document, similar to many constitutions around the globe, and therefore was always intended to be interpreted in an evolutionary manner. Your Excellency, that concludes my submissions on the first ingredient of 2.4, and I would now come to the second ingredient, which is whether there have been violation of the purposes of the UN Charter. Now, Your Excellencies would note the peculiar language of Article 2.4. It employs a catch-all phrase, in any other manner inconsistent with the purposes of the Charter. Now, this includes, under Article 1, Sub-Article 3, a desire and a necessity to preserve human rights under the international order. Now, if Your Excellencies would return to page 93 of the applicant's compendium. Your Excellency, on page 92, we have extracted a report of the UN Human Rights Council in its study of the negative impact of unilateral coercive measures on the enjoyment of human rights. Now, Your Excellency, the very first paragraph, paragraph 27, notes that the adverse effects of international coercive measures in general on the enjoyment of human rights of targeted populations have been widely documented. They affect the ability of the targeted country and, crucially, as well as that of third countries not involved in the dispute, to interact with the global business and financial community. Furthermore, Your Excellencies, if you would turn to page 79, Your Excellency, is not page 79, but rather page 87. Here we have extracted the general comment by the Committee on Economic, Social and Cultural Rights. I see that I'm running out of time. May I request an extension of 1 minute to conclude my submissions? Your Excellency, this general comment by the Economic Committee on the next page notes in paragraph 3 that while the impact of sanctions varies from one case to another, the committee is aware that they almost always have a dramatic impact on the rights recognized in the covenant. Speaking of the International Covenant on Economic, Social and Cultural Rights. Now, Your Excellency, if you would take note of the sanctions imposed in the present dispute, you would see how both the UNHRC's report as well as this general comment have precisely predicted the effects that these sanctions would take. The sanctions are indiscriminate and all-encompassing. They include a travel ban, a cessation of trade, as well as a ban on the the flow of currency between the states. Now, given the sweeping nature of these sanctions, we submit that the standards that have been codified in these reports would also be satisfied in this case, wherein these sanctions would have an overwhelmingly negative impact on both the economy of Endor as well as its society. And therefore, we submit that both ingredients of Article 2.4 are satisfied and tattooing sanctions indeed constitute use of force under Article 4.
Would you say that this was about coercion and therefore getting Indore to submit to the execution?
Indeed. Your Excellencies, if I may be of no further assistance, that concludes our submissions. We respectfully reserve 2 minutes for rebuttal. Thank you.
Am I audible? May I begin? Greetings to the Honorable Bench. The agent stands before this court on behalf of the respondents, the United Provinces of Alderaan and the Kingdom of Tatooine. There are 4 key issues before this court today. The agent shall be taking 13 minutes to explain issue 1 and issue 3, which deals with the legality of execution of the arbitral award under the New York Convention and the legality of an award being set aside by Endor. My co-agent will be taking 17 minutes to explain the second issue pertaining to Alderaan's execution against the Endorian assets, and the fourth issue pertaining to whether the measures undertaken by Tatooine against Endor comprise the use of force. Would Your Excellencies require a brief reiteration of facts? Certainly, Excellency. Your Excellency, the first issue is whether execution of the arbitral award by Alderaan that had been set aside by Endor violates the New York Convention. The agent argues that it in fact does not violate the provisions of the New York Convention. The following argument shall consist of 2 prongs. The first being that the word may of Article 5(1)(e) of the New York Convention makes the provision permissible in nature, and the second being that the more favorable right principle in Article 7 of the same convention permits national law to override the convention. Your Excellencies, Article 5(1)(e) of the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Award clearly utilizes the word may in its provisions. If Your Excellencies could refer to page 7 of the Respondent's Compendium, flag 1. Are Your Excellencies with the agent? May the agent proceed? Much obliged. Your Excellencies, as the applicants have rightly pointed out in their arguments, the respondents do contend that Article 5(1)(e) has not been violated, and the utilization of the specific word may makes the article permissible in nature. Thus, the seat of arbitration, which is Endor, rightly so, may set aside the award. However, there is no mandatory obligation to refuse the enforcement in another enforcing court. Your Excellency, the agent is contending that even if an award is set aside, it still does exist because it is part of the international regime and not the national order of the domestic country, the seat country. And that's why it can be enforced in another enforcing court if they meet the standard. May the agent proceed with the submission. Certainly, Excellency. The respondents are not claiming that there is no principle of territoriality. The respondents are respecting that. The seat can legally set aside the award. However, the set aside award can be enforced if there are certain conditions that are met. In this particular case, Your Excellency, there has been expropriation of $35.5 billion. And while the applicants claim that expropriation would not be considered, Your Excellency, in this particular regard, there has been unjust enrichment and there should be restitution for the same. Because they have taken the assets, 30% of the work had been done, and after that, the program was held as unconstitutional. And the award only talks about the damages, the $35.5 billion damages. And so Alderaan's law believes, it states, that this award is enforceable in their court. May the agent proceed with submissions? Much obliged, Your Excellency. Your Excellency, for the interpretation of a treaty, Article 31 and 32 of the Vienna Convention on the Law of Treaties must be perused. It clearly states that the preparatory work of the convention must also be regarded for interpretation if there is any contention between interpretation, as it exists between the applicants and the respondent in this particular case. Your Excellency, nothing in the TRAVO mentions any reference to the word may in Article 5.1. And further, New York Convention was introduced to supplant its predecessor, which was the Geneva Convention on the Execution of Foreign Arbitral Awards, 1927. Your Excellency, the Geneva Convention also talked about setting aside an award, but they used the word shall under Article 2. The move of the drafters of the New York Convention from the word shall to the word may clearly shows their intent to change this obligation of not enforcing a set aside award to discretion as per the enforcing code. Furthermore, Your Excellency, it is humbly submitted that according to Article 7.1 of the New York Convention, parties seeking recognition and enforcement shall not be deprived of the right to rely, in addition to the convention, on a more favorable domestic law or treaty. If Your Excellencies could refer to page 7 of the compendium, flag 1. May I proceed? Certainly, Excellency. Your Excellency, as previously mentioned, the provision employs the word shall in this particular article, Article 7, unlike Article 5. Thus, it implies a mandatory obligation. It is also submitted that Article 7.1 only makes sense if non-recognition is permissible under Article 5. Your Excellency, the agent would like to direct you to a case, Krumali versus Egypt, Arab Egypt. Your Excellency, may the agent read out the judgment of this particular case? Yes, certainly, Excellency. Your Excellency, this was a case in front of US District Court wherein they ruled in favor of enforcing the arbitral award, and they stated that Article 5.1 of the New York Convention allows discretion to deny enforcement of annulled awards, but Article 7.1 preserves a party's right to enforce awards under the local law. Under US law, they were allowed to enforce this particular award. Similarly, in this case, under Alderton's law, under what is decent and just, this award is enforceable, Your Excellency. Furthermore, Excellency, even if a country is the seat, an award cannot be perceived as belonging to the legal order of that particular country, and it is international in nature. If Your Excellencies could refer to flag 4 of the compendium, Respondent's compendium. Certainly, Excellency. May the agent proceed? Your Excellency, according to the complement, the facts of the case, Alderanian court considered the enforcement of the award in light of what was decent and what was just under their own national law, permitting the use of Article 7 in this particular regard. If there are no further questions to this particular issue, may the agent proceed. Sir. Your Excellency, in the particular case, they, according to Alderton's code, they said the award itself is applicable, is enforceable in the country. Further on, and this will be dealt further by my co-agent, since this is part of the second issue, second submission, Your Excellency, they allowed execution of the assets that were in their own land. Your Excellency, whether they considered Article 19 or not is something that my co-agent would contend. So may the agent proceed? Certainly, Excellency. Your Excellency, it is submitted that Endor violated its treaty obligations by erroneously setting aside the arbitral award. This shall be dealt in 2 prongs. The first being that the exception for public policy cannot be used in cases of expropriation, and second, the enforcement of an award cannot be refused because the underlying contract violated the public policy of the state. Your Excellency, the standard for enforcing an annulled award is that not doing so would be repugnant to notions of what is decent and what is just. And this implies that the standard of violation of public policy is extremely high, and it should be seen in a restrictive manner. The agent contends to that. But, Your Excellency, in the case of Pemex, Corporación Pemex versus Mexicana, if Your Excellencies could refer to flag 13 of the compendium, Respondent's compendium, flag 13. So, Your Excellency, in this case, it was stated that the exception of public policy cannot be invoked in cases where the government expropriates assets without providing compensation, and an enforcing court can refuse annulment with regards to same. Your Excellency, expropriation is interference with the assets of a party carried out by government in sovereign capacity. Your Excellency, in this instant case, according to the facts, Endor had expropriated Skynet's asset because 30% of the work had already been done as per clarification 12 of the additional annexure of the Comptribute. Thus, there had been expropriation, and this conclusion is also evident from the tribunal's judgment, which, after evaluating the case on merits, came to the conclusion of this award as per paragraph 10 of the Comptribute. May the agent proceed? Your Excellency, the enforcement of an arbitral award cannot simply be refused because the underlying contract violated the public policy of the state. It has been observed by most courts that while adjudicating the issue of whether an arbitral award violates the public policy of a country, the award can still be enforced despite the illegality or the voidability of the underlying contract. To deny enforcement, the award itself must clearly and precisely show that a clear direct conflict existed between the enforcement of the award and the state's public policy. Yeah.
If the award breaches the law of the country, such as Indore, then wouldn't that be in violation of public policy?
Certainly, Excellency, but in this particular case, the award only talked about the damages. There was no provision that the particular Stargaze program would be reinstitutionalized or would be continued again or something like that. Until now, there has been no violation of the right to privacy. It was a preemptive.
Is it because of the Skynet program? If the Skynet program was not there in the first place, then there would not be a question of damages. The whole issue is the Skynet program.
Certainly, Excellency, the whole issue is regarding this particular program, the Stargaze program. But Your Excellency, if the agent may quote a case in this particular regard, in St. Mary's Home versus Server Employee International Union, it was held that courts may refuse to enforce arbitral awards only in those rare cases when enforcement of the award would be directly at odds with a well-defined dominant public policy. The agent is not contending that right to privacy is not a dominant public policy or that it is not important in nature. It is certainly very important, right, Your Excellency. But in this particular regard, the award itself was not violating the public policy or the right to privacy. There has been no violation because no data has been given to the Tatuan government as of yet. Only 30% of the program had been done. Furthermore, Your Excellency, it is submitted that before the Honorable Court that Endor has committed an internationally wrongful act by erroneously setting aside the arbitral award and breaching its international obligation. It was held in the Rainbow Warrior case between New Zealand and France that general principles of international law concerning state responsibility are equally applicable in breach of treaty obligation. Further, Article 2 of the Responsibility of States for Internationally Wrongful Act, which is RCWA, it states that breach of an international obligation constitutes an internationally wrongful act. In this instant case, it is submitted that Endor had an obligation to enforce the arbitral award, and therefore the non-enforcement of this award leads to a breach of international obligation under Article 4.1 of RCWA, which states that the conduct of any state organ shall be considered an act of the state under international law, since it has been set aside by the Supreme Court of Endor. Your Excellency, it's also further stated that Endor must, just 10 seconds, Endor must pay compensation for the breach that they have committed under Article 36 of the RCWA. If the agent is of no further use, may the call upon the court. Much obliged, on a file presenting this case.
Greetings to the Honorable Bench. This agent will take 17 minutes of Your Excellency's time to deliberate upon Issue 2 and Issue 4. With your kind permission, may this agent proceed with his oral submissions. Regarding Issue 2, Your Excellency, this agent pleads to this court that the execution against Endorian assets is neither violative of the FSI nor customary international law. For the purposes of the submission, this agent has divided this issue into two main arguments. Firstly, FSI is the relevant applicable law. Secondly, the execution is not violative of the FSI. Regarding the first argument, Your Excellency, may this agent invite your kind attention to running page 6, para 17 of the written submissions. Are Your Excellencies with this agent? The written submissions. running page 6, para 17. It is pleaded in regard to the first argument that FSIA is the relevant applicable law. This will be contended in a twofold manner, where the first fold would show that the law on state immunity against execution is not customary in nature, and the second fold would show that ALRAN has a treaty obligation under the New York Convention to execute against Andorran assets. Regarding the first fold, Your Excellency, for any crystallization of the rule of customary international law, there must be two prongs to be satisfied. First, there must be widespread state practice in regards to that law. Secondly, consequently, such widespread state practice must be generally accepted as law. This would be called opinio juris. Approaching the applicant's contention on the customary nature of the UN Convention on Sovereign Immunities in totality, Your Excellency, a perusal of para 23 of Judge Yusuf's separate opinion in jurisdictional immunities, that is Germany versus Italy, with Greece intervening, Your Excellency, this very court would show that there are extravagantly diverging state practices regarding the law of state immunity against execution. In furtherance, opinio juris cannot be established in light of no established general practice in itself. This is adduced with all the sources starting from page 80 to page 94 of the Respondent's Compendium. Are Your Excellencies with this agent? It is very specifically highlighted in this judgment that the UN Convention on Sovereign Immunities is not reflective of customary law in totality, thus rendering the applicant's arguments that this was indeed a customary law void. To this extent, Your Excellency, there is indeed no law on sovereign immunity against execution which is customary in nature. Are Your Excellencies with this agent? Regarding the second fold, Your Excellency, of this very argument, a very specific perusal of Article 3 of the New York Convention would show that convention mandates contracting parties to recognize and enforce foreign arbitral awards under its domestic laws. If Your Excellency kindly observes the 2016 Secretariat's Guide to the Convention, if I may just read a small portion in front of Your Excellency, while recognition concerns recognizing the legal force and effect of an award, enforcement considers or concerns the forced execution of an award previously recognized by the same state. Herein, Your Excellency, enforcement has been equated to forced execution. As contracting parties to the convention are mandated to enforce foreign arbitral awards rendered through this very specific convention, ALRAN, a contracting party, was treaty bound to execute under the New York Convention. Your Excellency, going back to the previous round, even if there were any customary obligations, Your Excellency, this very specific treaty obligation under the New York Convention would override the less specific or the less special customary obligations, Your Excellency. This is a recognized principle of general law, general international law. This would be the lex specialis rule, wherein the more specific treaty obligation would overrule the customary obligations. Are Your Excellencies with this agent? Indeed. To this extent, Your Excellency, considering there is no customary obligation and there is indeed a treaty obligation, the treaty obligation under the New York Convention will apply, and to this extent, the execution was indeed valid in nature. Are Your Excellencies with this agent? Your Excellency, the second argument, may this agent invite your kind attention to running page number 5, para 16 of the written submissions regarding the second argument. This will be in regards to the execution and how it is concerned with the FSIA here, the domestic law. Your Excellency, the learned agents appearing from the applicant's side in the entirety of their second argument pertaining to this issue contend that there was a gross violation of the provisions of the FSIA by using FSIA jurisprudence and specific statutory provisions of the FSIA. In response to that, Your Excellency, in Lagrand, the Germany versus United States of America case, in this very court, Your Excellency, the International Court of Justice, Your Excellency, this court had adjudicated that this court may not be asked to become an ultimate court of appeal to any decision rendered by a domestic court at the domestic level using the domestic statute. Your Excellency, this would show that the final interpreters of the FSIA is indeed the Andorran court in this extent, and this court at any point may not have the jurisdiction to interpret the FSIA, Your Excellency. To this extent, by asking this court to adjudicate on whether or not the execution of endorsed assets was violative of the provisions of the FSIA, and to that extent, adducing FSIA jurisprudence and statutory provisions, the agents of the applicants are ultimately demanding that this court assume the nature of an ultimate court of an appeal. Your Excellency, this demand on this court would be unfounded in its very nature and would impose on this court to rule on the FSIA and not on customary obligations, Your Excellency. Are Your Excellencies with this agent? In essence, Your Excellency, the judgment that the Federal Court of Alderaan gave, may I take you to the compromise, Your Excellency? Page 6, para 18 of the court preamble. specifically elicits the judgment given by the Andronian Federal Court, Your Excellency. So this specific judgment would be the final interpretation of the FSI with regards to this specific issue at hand. Considering this is final, Your Excellency, it would still not be violative. That is, the execution would not be violative of the FSI itself. Your Excellency, in cumulation of this argument, we have one limited submission, Your Excellency. One, that there is no customary international law with regards to the execution. To this extent, there cannot be a violation of customary international law. Secondly, the FSI cannot be interpreted by this court, and the decision rendered by the Aldenian Federal Court will stand final. To this extent, Your Excellency, a very pertinent question, Your Excellency. To the extent that we are talking about Article 19C, that talks of the UN Convention on Sovereign Immunities, which speaks about sovereign funds. Your Excellency, indeed, there might be certain questions with regards to that. Your Excellency, sovereign assets are differentiated from acta jur gestionis, or assets used for commercial purpose. Herein, Your Excellency, these very specific assets that were used, herein they were used for development and benefit of infrastructure, which is a commercial purpose and a recognized commercial purpose to all. This would encompass acta jur gestionis as opposed to acta jur imprive, which would render the any claims under Article 19C void to that extent.
But wouldn't it be a central bank function? This would be a central bank function, even if it is used for that purpose.
Indeed, Your Excellency. Your Excellency, managing a sovereign fund, as noted by a famous jurist, Ingrid Brunk, as well as the ASCOM case in front of the Swedish Supreme Court, had very specifically held that sovereign funds are indeed, or managing sovereign funds is not a central bank function, Your Excellency. To this extent, even if Article 21(1)(c), Swedish Supreme Court, ASCOM Industries, Your Excellency, very specific judgment which points out to sovereign funds and whether or not they would encompass a function of the central bank. To this extent, it has been ruled vehemently that it would not be a central bank function. To this very extent, Your Excellency, this cannot invoke the Article 21(1)(c) or central bank absolute immunity in front of this very court. Are Your Excellencies with this agent? If this agent may be of no further assistance with regards to issue 2, if this agent go to issue 4. Regarding Your Excellency, regarding issue 4, this agent pleads to this court that the economic measures against Endor do not comprise a use of force. For the purposes of this submission, this agent has divided this issue into two main arguments. Firstly, that economic measures indeed do not comprise the use of force. Secondly, economic measures taken by Tatooine against Endor were valid countermeasures governed under Article 22 of the Articles of State Responsibility for Endor's non-compliance with its treaty obligations. Regarding the first argument, Your Excellency, may this agent invite your kind attention to running page number 15, para 52 of the written submissions. Are Your Excellencies with this agent? Okay. Regarding this argument, Your Excellency, this agent pleads that the economic measures do not comprise use of force, which will be contended in a twofold manner. The first fold would show that economic measures have generally not been considered as use of force. Secondly, it would pertain to use of force and its non-interpretation and cannot be interpreted by virtue of the VCLT or the Vienna Convention of the Law of Treatises to be encompass economic measures within its ambit. May this agent proceed? Regarding the first fold, Your Excellency, use of force under Article 2(4) of the UN Charter refers to immediate and dangerous threats of peace. This is evidenced very clearly by the analysis of the Travaux Préparatoires or the preparatory work of the UN Charter, Your Excellency, where a proposed amendment by the Brazilian delegate to include economic measures within the scope of use of force was explicitly rejected. Your Excellency, to adduce to this explicit rejection, any attempt to include within the scope of use of force within the next 30 years, Your Excellency, including economic measures within the use of force, may I just point out the resolution 2625 that the applicants brought in, Your Excellency. The very resolution 2625 that the applicants bring in separately deals with use of force, and in the next page deals with principle of non-intervention or economic measures, Your Excellency. Your Excellency, I may even point out the specific page numbers. Page number 122 of this resolution, it is not currently there in the compendium, but page 122 of this resolution deals very specifically with use of force, then separately deals in page 123 with the connotations on economic coercion or any form of coercion. At any point, it has not been quantitatively equated, Your Excellency. To this extent, use of force cannot be equated to economic measures at any point. Your Excellency, The same was the case with the 1974 definition of aggression, another attempt to include economic measures within the scope of use of force. And Your Excellency, this would also be the case with the 1987 Declaration on the Non-Use of Force, Your Excellency. So over a span of 40 years, Your Excellency, to around 45 years at this point, Your Excellency, economic measures were vehemently rejected from being included within the ambit of use of force. It has to be restricted to imminent and dangerous threats to peace and harmony, Your Excellency. Are Your Excellency's decision? Your Excellency, very pertinent question. Your Excellency, when you say data transfer, I would assume that you are speaking about cyber warfare and cyber operations, Your Excellency. Article 38(1)(d) would also include any eminent jurist opinions, Your Excellency. If I may say side 1, the talent manual, Your Excellency, is concerns cyber operations and cyber warfare. To this extent, the jurist Michael N. Schmidt very specifically dealt with it being considered use of force. There is cyber operations based on its scales and effects, based on its gravity, would be comprising use of force, Your Excellency. It is our submission that indeed cyber operations of this kind can be considered use of force, but Your Excellency, at this point, economic measures will have to be drawn separately, and by this divergence, economic measures at any point cannot be considered use of force. Are Your Excellency's decision? Indeed. If Your Excellencies are convinced with this argument, may this agent proceed to the interpretation argument. Regarding the second point, Your Excellency, any attempts to interpret Article 2(4) of the UN Charter to include economic measures within the realms of use of force must conform to Articles 31 and 32 of the Vienna Convention of Peace. Your Excellency, in light of no previous agreements which specifically include economic measures within the scope of use of force, that is under Article 2(4) of the UN Charter, Your Excellency, it would be imperative to consider the preparatory work first and talk about the subsequent state practice itself, Your Excellency. As previously submitted, Your Excellency, the explicit rejection of the Brazilian proposal is evidence enough to show that there was no intention at any point to even consider a point or a concept of economic force. Your Excellency, use of force in the form of Article 2(4) of the UN Charter has been afforded jus cogens nature. Your Excellency, a jus cogens norm would be a peremptory norm of international law which has universal acceptance. And Your Excellency, any scope or any modification of the scope of the use of force, considering it is a jus cogens norm, will have to meet the same universal threshold. Now, Your Excellency, everyone is in agreement that armed attacks are indeed use of force because it is a universal law. But no one is in agreement with regards to there is diverging state practice to the extent that economic measures may or may not be considered. To this extent, only a jus cogens norm may replace a jus cogens norm, and to this extent, an economic measures cannot be enlarged within the scope of the use of force. Are Your Excellencies with this agent? Your Excellency, the applicants indeed brought the scales and effects argument under the Nicaragua judgment, that is 1986, Your Excellency. This very parameter of scales and effects cannot be applied to the express case as contended by the applicant in light of the fact that this very case dealt with the principle of non-intervention, economic measures, and separate paramilitary activities. Now, Your Excellency, the very same judgment that prescribes the scales and effect test chooses not to use the very same parameter when it comes to the question of economic measures, differentiates it to call it principle of non-intervention. By this regard, Your Excellency, economic measures indeed has to be diverged from the concept of use of force, and it has to be dealt with separately. At the best, Your Excellency, it is still a limited submission that it can be tried with the test of principle of non-intervention, but at no point can be considered use of force. May this agent proceed to the arguments of countermeasures, Your Excellency. Your Excellency, the finality of our arguments would talk about valid countermeasures. As previously submitted by my co-agent in pertinence to issue 3, Your Excellency, endorse non-compliance with the New York Convention comprises an internationally wrongful act because it is a violation of a treaty obligation, to which Tatooine had responded with some economic measures. Your Excellency, may this agent take 2 minutes of extension. 1 minute. Indeed. Your Excellency, regarding this, there are 3 essential conditions that may be fulfilled to comprise a valid countermeasure. 1, they must be valid or legitimate in nature. 2, the countermeasure must be proportional in nature. 3, that the countermeasures must be aimed at inducing the wrongful state to comply with its treaty obligation. Herein, Your Excellency, if I may just take you to running page 7, para 20 of the compromise. Yes. Your Excellency, there is a clear indication that the countermeasures were taken specifically to induce Endor to comply with its treaty obligation. On the second count of proportionality, Your Excellency, we do concede that the abstract concept of proportionality is very abstract in international law. But Your Excellency, in Gabchikova and Agimoros, a very specific judgment by the International Court of Justice, it had proposed a quantitatively equivalent metric, Your Excellency, to show that the cause of action must be quantitatively equivalent to the countermeasure. To this extent, we are speaking of a $35.5 billion lost, Your Excellency, today, and the gravity of this matter must be considered. To this extent, it is quantitatively equivalent and is indeed proportional in its nature. Your Excellency, this very court in hostages, that is the Iran versus the United States of America and Air Services Agreement, very specifically held that economic measures are indeed valid and legitimate countermeasures. Your Excellency, in cumulation, considering they are valid, considering they are legitimate, considering they are proportional in nature, and in finality, they are trying to induce the wrongful state to comply with their treaty obligation, they must be indeed considered as legitimate countermeasures which must be precluded of their wrongfulness at this count, Your Excellency. Are Your Excellencies with this agent? Indeed. It was an honor to argue before this court.
Your Excellencies, may I begin? Three brief points of rebuttal, Your Excellency, two on issue 2 and one on issue 4. On issue 2, Your Excellency, firstly, respondent has contended that the UNCSI is not reflective of customary international law. Indeed, it is not, Your Excellency, and we do not seek to rely on the convention. We rely on customary international law as it is found in state practice and opinio juris, and both of these elements clearly accord a restrictive immunity to central bank property. I could cite a catena of authorities on this particular point, but for the moment, I would cite the Australian legislations, the US, the French, Swedish, Dutch, and even German legislations which grant this immunity. The second point of rebuttal, Your Excellency, the respondents contended that the New York Convention governs execution. We reiterate that this fails to note the important distinction between enforcement and execution. If I may offer an example by analogy, Your Excellency, if indeed the New York Convention governed execution, there would be no need for an FSI within Endor at all. Rather, execution could have been governed by the Indorian Arbitration Act. The very fact that the FSIA exists and provides separate procedures for execution is reflective of the fact that execution is a distinct part of the post-award process. On issue 4, Your Excellency, one very brief point of rebuttal. The respondents mentioned the Talon Manual, which is reflective of a growth in international judicial thought that cyber attacks can constitute use of force also. Your Excellency, this supports precisely the point the applicants are trying to make, which is that if use of force can expand to include cyber attacks, why not economic force? The principle underlying both is the same, which is that this court is empowered to adopt an evolutionary principle of interpretation so as to give Article 2.4 a dynamic life so that it can adapt to developments in international relations. Your Excellency, with that, we conclude our submissions. We maintain with full effect our prayer on record. Thank you very much.
Your Excellency, just 3 points, Your Excellency. Very specifically, the applicant's agent started in this very court to state that the UN Convention on Sovereign Immunities was indeed customary in nature. Now they're relying on a very separate fact, Your Excellency, to state that very specific portions of the UN Convention on Sovereign Immunities is customary in nature. Further on, they went on to state that the state practice that they were relying on. Your Excellency, it is our one and only submission that the UN Convention on Sovereign Immunities is in totality not reflective of customary law and this does not reflect state practice at any point. Your Excellency, the next point is that with regards to enforcement, including execution with regards to the New York Convention. Clearly defined in the New York Convention, but the additional source, as can be seen by the Secretariat to the guides to the Convention, Your Excellency, would include forced execution to be part of enforcement. Your Excellency, the distinction would be immaterial in regards to the New York Convention because the New York Convention mandates that there must be forced execution to this extent. So indeed, Your Excellency, there was no violation with regards to the execution. Your Excellency, may this agent just make one final point. Indeed, Your Excellency. Your Excellency, they had contended with regards to the evolutionary interpretation of law, Your Excellency. We just saw the GA Resolution 2024 with regards to USA's intervention into Cuba. Your Excellency, that would be the pinnacular example of economic measures, and even that wasn't considered use of force, Your Excellency. That still applies the principle of non-intervention, and there was no question of use of force. If that doesn't show state practice, Your Excellency, what would, Your Excellency? May this agent just rest his argument.
The final round of arguments is now over. I request everybody to remain seated while we escort our judges. I request everyone to remain seated. We'll begin with the valedictory function shortly. Bombay High Court, trustees of the D.M. Harish Foundation, senior counsels and counsels of the Bombay High Court, Madam Principal Dr. Mrs. Asmita Vaidya, Professor in Charge Assistant Professor Nuzhat Sheikh, Professor Kishu Daswani, members of the Moot Court Association, and ladies and gentlemen. It is a great honor for us to welcome everyone present this evening to the valedictory function of the 26th D.M. Harish Memorial Government Law College International Moot Court Competition 2025. To begin the evening on a solemn note, we shall now commence with the Saraswati Vandana. I would like to request our esteemed dignitaries to come forward for the lighting of the lamp. I would now like to request our dignitaries to take their place on the stage. The D.M. Harish Memorial Moot Court Competition is jointly organized by Government Law College Mumbai and D.M. Harish Foundation, a trust instituted in memory of one of India's most eminent jurists, Mr. D.M. Harish, an alumnus of Government Law College Mumbai and an authority on income tax law. With a heritage spanning a century and a half, Government Law College Mumbai has dominated the legal landscape of India since its inception in 1855. This competition was the first international law moot court competition in India and has emerged as the most prestigious mooting competition of its kind in the country, playing an important role in giving impetus to mooting in India by providing a platform for law students to hone their advocacy skills. With teams from the United Kingdom, USA, Singapore, Mauritius, Spain, Greece, Ireland, Australia, Sri Lanka, Bangladesh, Nepal, and many other countries having participated in this moot court competition across multiple editions, this moot truly encapsulates a global spirit and experience. Our dignitaries for today were thoroughly impressed by the fine display of advocacy by the finalists. The 2025th edition of this moot saw 30 teams participating from all over the world. The case study of the competition, dealing primarily with issues relating to public international law, was drafted by Mr. Rohan Lavkumar, Managing Partner of Nanavati Associates. We have amidst us today our Madam Principal Dr. Asmita Vaidya, a university ranker at the graduate and postgraduate level with an MBA in Human Resource Management. She pursued doctoral research in industrial law and did her PhD in the year 2006. She started her career as a teacher at the Postgraduate Department of Law, Nagpur University, in the year 1995. Dr. Vaidya has chaired many technical sessions and delivered many lectures as a resource person on different legal topics such as cyber law, intellectual property law, human rights, women's rights, and surrogacy, to name a few. I would like to thank Madam Principal for the guidance and direction that she has provided to the Moot Court Association and its endeavours. We now request our Madam Principal to kindly say a few words.
माँ सरस्वती ला वंदन। Honorable Shri Justice Riyad Chawla sir, Honorable Shri Justice Kamal Katha sir, Honorable Shri Justice Firdos Puniwala sir, Judge Bombay High Court, Mumbai, all the trustees from DM Harish Foundation, all the professors who are present here, all the team members who could reach Mumbai for the competition, and my beloved students. Very good evening to one and all. It is definitely a proud feeling for us that we are conducting DM Harish Memorial Government Law College International Online Moot Court Competition from last 25 years, and this is the 26th edition of the joint venture. The Moot Court competition definitely provides a platform for law students from across the globe to develop into intricacies of international law and avail of an excellent opportunity to develop their advocacy skills. This international Moot Court competition is definitely a key event of our college. As you all know, Government Law College has been established in the year 1855 and carries legacy. This college is proactive and conducting many programs, seminars, conferences, Moot Court competitions, and many more because of the constant support of the Governing Council. And we are conducting many programs in collaborations with the big people like Harish Foundation. We have received this time 34 entries and 34 participating teams, out of which 3 are international, others are from different parts of Bharat. I welcome and appreciate all the 8 teams who could reach Mumbai for their semi-finals and finals. I also appreciate their performances and in advance would like to congratulate them for their participation as well as for gaining the position in the competition. I would like to appreciate the cooperation, guidance and suggestions given by the trustees of DM Harish Foundation, particularly all the luminaries who are sitting here, Anil Harish sir, Sharan Jagtiani sir, Shobha Jagtiani madam, and all others who have contributed in making this event successful. I really appreciate all the efforts taken by MCA team, GLC MCA team, because all the while they are struggling and they are actually planning very nicely this event, and I appreciate all of them for making this event successful. I welcome you all in this valedictory function. Secondly, I must mention that all the eminent judges from the Bombay High Court have given their time for the final rounds, and therefore I must express my gratitude from bottom of my heart for coming to GLC and giving their precious time for us, and even now they are going to address us. So I welcome you all for this valedictory function. Thank you very much.
Thank you, ma'am, for those lovely words. We also have among us today our beloved Professor in Charge, Assistant Professor Nuzhat Sheikh. Professor Nuzhat Sheikh joined GLC as an assistant professor in the year 2013. She holds a BSc degree and has qualified for the Junior Research Fellowship and National Eligibility Test in Law, Criminology, and Human Rights and Duties. She is a PhD research scholar and has over 30 national and international publications. I would now like to call upon Assistant Professor Nuzhat Sheikh to say a few words.
Yeah, good evening, everyone. Myself, Assistant Professor Mrs. Sheikh Nuzhat Afroz, GLC, in charge Faculty Moot Court Association, Honorable Mr. Justice Riaz Chagla, Judge, Bombay High Court, Honorable Justice Kamal Kata, Judge, Bombay High Court, Honorable Justice Firoz Poniwala, Judge, Bombay High Court, Honorable Principal Dr. Asmita Vaidya, respected faculty members, participants, and my dear students. I would like to begin with a quote. If liberty means anything at all, it means the right to tell people what they do not want to hear. By George Orwell. It gives me immense pleasure to welcome you all for this DM Harish Memorial Government Law College International Moot Court Competition 2025, organized by the Government Law College Mumbai in association with DM Harish Foundation. The collaboration of Government Law College Mumbai with DM Harish Foundation has always been in forefront in providing the opportunity and platform not only to the student of JLC but also to the student from Pan India as well as from the foreign countries to exhibit their talents, embark the solace of knowledge in the field of law concerning the topics of national and international interest. We thank DM Harish Foundation members for their continuous support and the encouragement for organizing such an event since 26 years, looking forward to explore the new areas of the student-centric events and activities. The International Moot Court competition has started on 26th with the preliminary and the quarterfinal rounds. The final rounds were conducted on 27th March 2025. 30 teams have participated this year, and we have participants from abroad also, from other foreign countries. And the most awaited final round of the Moot Court was conducted today on 29th March 2025. And all the rounds of the Moot Court competitions were conducted very smoothly and effectively by the Moot Court Association members and the volunteers. I congratulate all the participants without whom this competition would not have been reached the height of success. And the first session, we had the panel discussion on the 28th March 2025, which had given an opportunity to all the students and the audience to witness and experience the views and the opinions of the subject experts and the panelists who had presented their stance with prudent and logical reasoning and making it a versatile deliberation in understanding the core issues related to the topic of discussion, free speech and censorship in the age of social media, necessity or overreach. So on this note, I congratulate all the participants and the winners of this competition. I thank the Honorable Mr. Justice Riaz Chagla, Judge, Bombay High Court, Honorable Mr. Justice Kamal Khata, Judge, Bombay High Court, Honorable Mr. Justice Firoz Poniwala, Bombay High Court, and I express my gratitude to Dr. Asmita Vaidya, Madam Principal, Government Law College, Mumbai, and the organizing committee of the Moot Court Association for giving me an opportunity. I thank Tanisha Singh, General Secretary, and all the Moot Court Committee members for their continuous effort in making this event a grand success. Thank you.
Thank you, ma'am, for your words of wisdom. Over the last 25 glorious years of this competition, DM Harish Foundation has always provided the Moot Court Association with unwavering guidance and support. We extend our most sincere gratitude to Mr. Anil Harish and Mrs. Shobha Jagtiani, along with all members of the Harish and Jagtiani family, for their immense contribution and continued assistance. I request Mr. Anil Harish, trustee of the DM Harish Foundation, to kindly address the audience.
Honorable Judges of the Bombay High Court, Principal of Government Law College, Dr. Asmita Vaidya, Professor Sheikh Nuzhat, Professor Kishu Daswani, and other distinguished professors, Ms. Tanisha Singh, Ms. Disha Sonavani, and members of the Moot Court Association and volunteers, fellow lawyers, ladies and gentlemen, and dear students. We are honored by and particularly grateful to the Honorable Judges of the Bombay High Court, Honorable Mr. Justice Riaz Chagla, Honorable Mr. Justice Kamal Khata, Honorable Mr. Justice Firdosh Pooniwala, who have constituted a 3-judge bench and judged the final round of the Moot Court competition. Sirs, you have given so much time today, and we have taken you away from all the numerous matters that you have and the judgments that you have to dictate and correct. Thank you very much. Albert Camus said, "Real generosity towards the future consists in giving all to what is present. Your lordships have so generously bestowed your time, knowledge, and experience and asked such important questions. It is apparent that your lordships have done so much study and have truly been bountiful in your generosity to the future. It inspires all of us when we see what you do in the cause of education and for society." I thank all the senior advocates and other lawyers who have so willingly come forward and judged the rounds. They have contributed a great deal over the years to this Moot Court competition and have guided the students. This is what makes anything to do with education so extraordinary and so satisfying, to see how many can participate in this great cause and give of themselves. The case itself was excellently drafted by Mr. Rohan Lavkumar. It was a challenge not only to the student advocates, but also to those who judged it, as it contained many complex facts and unusual issues. I am grateful too to Mr. Shwab Chakravarti, Mr. Jobi Noble, Mr. Alak Anantlal, Mr. Danish Nethani, Ms. Idika Agarwal, Ms. Nupur Gupte, Mr. Sunan Subramaniam, and Ms. Sumriya Podar, who judged the memorials, and to Ms. Padma Lakshmi Panchal and Ms. Radhika Chaparia, who authored the bench memorandum. Student advocates from 30 universities and colleges in India, of which 3 were from overseas, from Brunei and from Nepal, have been brilliant. All of you studied so well and have done so much research. I'm sure that this will stand you in good stead in the future. So even if you have not got a prize, remember that in education, everyone is a winner. Of course, a Moot Court competition is not just about winning or losing. It's about learning. If you have learned the art of thinking on your feet, responding to unexpected questions, and keeping a straight face when a judge stares at you for an uncomfortably long time, you're already halfway to becoming a good lawyer. Nelson Mandela said, "I either win or I learn." So even if you have not won a prize, count this as part of experience, and I'm sure you will do better as time goes on. I am so grateful to Principal Dr. Asmita Vaidya and Professor Sheikh Nuzar and Professor Kishu Daswani and other professors who have guided the students and have always been there for the MCA. In addition, I give my thanks to the professors of the other participating colleges who have mentored the students and enabled them to come here and argue so well. Thank you for your unwavering support and guidance. The panel discussion yesterday was on a very important and topical and controversial subject: free speech and censorship in the age of social media, necessity or overreach. The panelists were Justice Gautam Patel, retired, Mr. Haim Devan, former Ambassador of Israel, Mr. Ashwin Sanghi, author, Mr. Cyrus Brocha, Ms. Aarti Raghavan, and Professor Kishu Daswani, and was moderated as always by Mr. Harish, senior advocate. Each of the speakers was brilliant, and the insights shared by the distinguished panelists and moderator have given us so much to reflect upon, reminding us that law is a living, breathing entity, evolving with society and responding to new challenges. The Moot Court Association, headed by Ms. Tanisha Singh and Ms. Disha Sonavani, and comprising 11 members and with 40 volunteers, has been, as always, wonderful. Right from planning the entire program, looking after the participants, preparing the bench memorials, and attending to every aspect. You are truly special. Thank you. I want especially to thank all the trustees and members of the families.
Mrs. Shobha Jaktiani has always given so many ideas and worked so hard, usually behind the scenes. Thank you, Shobha. And Harish, Hani, Sharan, Adiraj, Rishika, and Anushka, and all at DM Harish and Company. All of you have played such an important part. I'm very grateful to all those who have participated in and been involved with this competition, and to all who have come to hear the panel discussion and the finals and have encouraged all of us. George Bernard Shaw said, "It is a duty of each one of us to ensure that the candle burns more brightly when we pass it on than when we received it." Your Lordships, professors, advocates, and friends, thank you for doing just that. As we close this remarkable event and encourage all our participants to carry forward the lessons learned here, remember, the true mark of a lawyer is not just how they will argue, but how they will listen, analyze, and most importantly, seek justice. To paraphrase Justice Ruth Bader Ginsburg, fight for the things that you care about, but do it in a way that will lead others to join you. With that, I once again congratulate all the participants, organizers, and judges for making this competition so memorable. May your journey be filled with wisdom, wit, and just the right amount of caffeine. Thank you.
Thank you for those thoughtful words, sir. We have with us today Honorable Mr. Justice Riaz Chadha. His Lordship completed his graduation from HR College of Commerce and Economics, Mumbai University in 1991 and graduated in 1993 from the University of Cambridge, Downing College. His Lordship enrolled as an advocate with the Bar Council of Maharashtra and Goa in 1993 and practiced as a counsel at the Bombay High Court for over 23 years. His Lordship also appeared in the Honorable Supreme Court of India and was appointed to the Union Panel in 2009. His Lordship represented the central government in cases under the PMLA, NDPS Act, FEMA, and more. During his Lordship's practice as a counsel, he appeared in civil, constitutional, commercial, corporate, intellectual property, taxation, and testamentary cases. His Lordship was elevated as a judge of the Honorable Bombay High Court on 5th June 2017. I would like to invite Mr. Anil Harish to felicitate Honorable Mr. Justice Chadha. Thank you, sir. I would now like to request His Lordship to kindly address the participants.
Mr. Anil Harish, trustee of the DM Harish Foundation, Mr. Anil Harish's family who is here, Mrs. Shobha Jaktiani, trustee of the DM Harish Foundation, her family who is here, of course, Mr. Harish Jaktiani who is here, and Principal Asmita Vaidya, the professors in charge, Mrs. Nusrat Sheikh, the students who are in charge of this competition, Mr. Kishu, Kishu who is here, Professor Kishu Daswani, the other professors who are here, students, ladies and gentlemen, and of course my brother judges who have also come here to judge the competition along with me. It's indeed a privilege to judge the finals of the DM Harish International Moot Court competition. This is the 26th year of the DM Harish International Moot Court competition. The organizers have done a stellar job in organizing this year's competition, as they have always done so in the past. It attracts the best of talent among students, and this can be seen from the finalists today. In fact, in the past, I've also judged the DM Harish International Moot Court competition, and the talent which this competition brings is from all over the world. I have judged students from Cambridge University, Oxford, and other universities. In fact, now, as Mr. Harish has mentioned, it's become hybrid. The earlier rounds are online, and then the semi-finals and finals are in person. What I'd like to say about this year's Moot problem is that it was extremely well selected. Apart from the international law, the intricacies of international law, which were involved in the problem, it also raised issues on execution of awards on the one hand, and setting aside of awards on ground of public policy on the other. As a judge of the Bombay High Court, and Mr. Sharan Jaktiani, the senior counsel who is here and a close friend, and the others who are aware who practice in court, I've had an opportunity of deciding execution law matters as well as arbitration matters. And the issue of public policy which is involved in today's moot court problem is a very, very important issue which judges have to face, where there are challenges to awards. And apart from such challenges which do arise in arbitration law matters and which are handled by us judges, there is also the issue of execution. It is well known that unless an award is executed, it remains a paper decree. Now, coming to public policy, the law which relates to setting aside an award, and I talk from the purview of Indian law, has undergone a sea change over the years. Now there's a very limited scope of challenge to an award on ground of public policy. The award is held to be in contravention of public policy if it is in contravention of the fundamental policy of Indian law, or it conflicts with the basic notions of morality or justice. As the courts have held that the award must shock its conscience for the ground of public policy challenge to be upheld. Today's mooters, the finalists, have addressed these issues extremely well. There has to be a winner and a loser in every competition, but the important thing is to take part. I compliment both sides for their participation, as well as the other participants in the competition, and for these finalists to make it to the finals. What I realized whilst judging the final moot court competition is that both the finalists were extremely well prepared, and the questions put to them by us High Court judges were very confidently answered, and in fact it hardly took them any time to answer the questions. That showed their level of preparation. In fact, it was a very, very close decision which we had to make as to who would win this competition. But that was left to us, and we had to make that decision. I would just like to say that it's been a pleasure for me to come here and hear such finalists who have prepared themselves, and I'm sure it must have taken them a lot of time to prepare, and they've done exceedingly well. I would like to wish the finalists as well as all the participants in this competition the very best, and I do hope that ultimately they decide to choose the legal profession, they become counsels and appear before us at some point of time. Thank you.
Thank you, Your Lordship, for those encouraging words. We have with us Honorable Mr. Justice Carter. His Lordship did his schooling from Mahindra Students' Academy and completed BCom from HR College of Commerce and Economics. He studied law at Government Law College, Mumbai and graduated in law from KC Law College, Mumbai. He enrolled as an advocate in the year 1993 and has appeared in matters related to company law, property law, testamentary law, admiralty law, arbitration law, trademarks law, writ petitions, and public interest litigation, and conducted arbitration both as an arbitrator and as a counsel. His Lordship is also the honorary legal advisor to various LAD community trusts and an honorary lecturer at KC Law College. His Lordship was appointed as additional judge of the Bombay High Court in the year 2022, further elevated as a permanent judge in 2024. I would like to request our Madam Principal, Dr. Asmita Vaidya, to felicitate Honorable Mr. Justice Khata. I would request His Lordship to address the public.
Good evening, everyone. My brother Riaz, my brother Kuniwala, my friends here at the bar, Sharon, Rishika, they were my chamber colleagues. Mr. Anil Harish here, Ms. Shobha Jagtani, Mr. Senior Harish, and all of you friends here, the principal, and Ms. Sheikh, who is also the in charge of the Moot course. All of you all have done a wonderful job. It was indeed a pleasure to be here. This event is tested the intellect of people. It is thought-provoking. It strengthens the resolve of a student to become a future advocate, an advocate for justice. Reaching this stage is no small feat, and each of you should take immense pride in your journey that you have traveled here. Moot court is more than just an academic exercise. It is proving ground where one sharpens one's ability to think critically, argue persuasively, and uphold the principles of fairness and justice. Justice Antonin Scalia, the judge of the Supreme Court, once said, "The lawyer's truth is not truth, but consistency or a consistent expediency." Competition has shown us that in the courtroom, it is not just what about you believe to be right, but about how well you defend your position with logic, evidence, and unwavering conviction. Throughout this journey, all you students have demonstrated resilience, research skills, and ability to think on your feet. We saw a fantastic demonstration today when the judges asked questions to these people and they were very promptly answering them without batting their eyelids. These qualities define the finest legal minds. Whether you are arguing for a prosecution or a defense, plaintiff or a defendant, whether you win or you don't, it doesn't matter. Law is not just about winning arguments, it is about serving justice. For all you young minds, when you step forward in life as an advocate, remember to develop confidence but without arrogance, passion but without aggression, and knowledge with humility. It's very, very, very important. This will make you not just great mooters, but fantastic lawyers. This is what we are looking out for. We hope to see more students participating for these wonderful experiences. I must share with you one thing which is too personal, but Firdaus and I were in the same class. We both attended moot court competitions. Whilst I was sitting like one of you all there, having lost my things, he was the best moot court. So you don't have to feel that, okay, if someone is the best guy here as the moot court winner and you are sitting up there, you should lose hope. You can always strive harder. And today, I have the privilege of sharing the dais with him. So, you must not lose hope. All the best to all of you. You all did a wonderful job. Thank you for inviting me. Thank you very much.
Thank you, Your Lordship, for those words of wisdom. We also have with us today Honorable Mr. Justice Pooniwala. His Lordship did his schooling from Don Bosco High School, Mumbai, after which he joined the Ram Narayan Ruya College and obtained a BA degree from Mumbai University in 1990. Having joined Government Law College, Mumbai, he obtained his LLB degree in 1993. His Lordship passed the solicitor's examination conducted by the Bombay Incorporated Law Society in November 1994, thereby becoming a qualified solicitor. Having worked at a reputed law firm for 4 years, he joined the chambers of Mr. N. H. Sivai in 1995. His practice spanned across various fields of law like civil, commercial, and property disputes, constitutional law, and arbitration disputes. He was designated as a senior advocate by the Honorable Bombay High Court on 16 February 2023. Later, his Lordship was sworn in as an additional judge of the Honorable Bombay High Court in 2023, further elevated as a permanent judge on 7th March 2025. I would like to request Assistant Professor Nuzhat Sheikh to felicitate Honorable Mr. Justice Pooniwala. I would now like to request His Lordship to address the gathering.
Justice Riaz Chadha, Justice Kamal Khata, Dr. Vaidya, Principal of Government Law College, Trustees of the DM Harish Foundation, my dear students, ladies and gentlemen. It is indeed my honor and privilege to be invited here to judge the finals of this moot court competition. I started my journey in law from this very college. I would regularly participate in moot courts and even win prizes. For someone like me who did not come from a legal background, winning a prize was one of the turning points of my life, as it gave me the necessary confidence to pursue a career in law as a counsel. I was more than delighted when once one of our professors, Mr. Rajiv Moite, who was then a practicing lawyer and who later on became a judge of the Bombay High Court, told me that we moot courters argued better than many practicing lawyers in the Bombay High Court. Therefore, it gives me great pleasure to come back here every time to this very college and to this very auditorium to judge a moot court competition. Now, whilst there are many things common for success in a moot court and success in an actual court, like being a master of the facts and having knowledge of the concerned law. There is one big difference between them. In an actual court, you prepare to win the case, whilst in a moot court, you do not prepare to win the case, but you prepare to win the competition. In a moot court, your arguments and presentation should be such that you present something novel and different, which catches the eye of the judge and which makes you stand out and win the competition. Another thing that you must remember in a moot court is that sometimes judges deliberately ask you questions to which the answers are obvious in order to test you and to see whether you lose your cool. Never ever lose your cool. And whether in a moot court or in an actual court, be honest and truthful to the judge. The worst thing that you can do is try to mislead a judge. Even if you try it once, the judge will never trust you. Once an honest lawyer had passed away. He was buried and the tombstone said, "There lies a lawyer and an honest man." A passerby on seeing the tombstone was aghast and shouted, "Oh my God, they have buried two men in the same grave." I am sure that all of you would like to dispel such a notion of a lawyer. In conclusion, I would like to state that we were very impressed with the quality of the competition here today. All the participants have a great future as lawyers. Maybe some of them may decide to become judges. Wishing you all the best. God bless all of you.
Thank you, sir, for those enriching words. I would now like to request our General Secretary, Tanisha Singh, to felicitate Madam Principal, Dr. Mrs. Asmita Ved. Thank you. Next, I would like to request our Assistant General Secretary, Ms. Disha Sunavni, to felicitate our Professor in Charge, Assistant Professor Nuzhat Sheikh. Thank you. We shall now begin with the most awaited segment of today's evening, the declaration of the results. To begin with, the winner of the award for the second best memorial is Team Code 5, Institute of Law, Nirma University. Next, the winner of the award for the best memorial is Team Code 23, Symbiosis Law School, Noida. Since both the teams are unable to join us today, we proceed to the next award. The winner of the award for the second best speaker is Speaker 2 from Team Code 6, School of Law, Christ, deemed to be University. Next, the winner of the award for the best speaker is Speaker 2 from Team Code 2, National Law University, Delhi. Since both the teams are unable to join us today, we proceed to the next award. Thank you. The winner of the award for the best speaker in the final rounds is Speaker 2 from Team Code 24, Rajiv Gandhi National University of Law, Punjab. I would like to request Honorable Mr. Justice Pooniwala to present the award for the best speaker in the final round of arguments. Thank you. The winner of the award for the best team is Team Code 1, National Law School of India University, Bangalore. I would request Honorable Mr. Justice Chawla to present the award for the best team. Congratulations to the winners. The winner of the award for the second best team is Team 424, Rajiv Gandhi National University of Law, Punjab. I would like to request Honorable Mr. Justice Khaka to present the award for the second best team. Thank you. Congratulations to all the winners. I would like to call on stage Ms. Tanisha Singh, General Secretary of the Moot Court Association, to deliver the vote of thanks.
Honorable Mr. Justice Riaz Chagla, Honorable Mr. Justice Kamal Khada, and Honorable Mr. Justice Firdaus Pooniwala, Dr. Mrs. Asmita Vaidya, Trustees of the D.M. Harish Foundation, Assistant Professor Nuzhat Sheikh, participants, ladies and gentlemen. It has truly been a privilege and an honor for the Moot Court Association of Government Law College to organize and host this event in association with the D.M. Harish Foundation for over 25 glorious years in memory of the late Mr. D.M. Harish, an alumnus of Government Law College and one of the greatest taxation experts that India has ever seen. On behalf of the Moot Court Association, I would like to sincerely extend my gratitude to Justice Chagla, Justice Khata, and Justice Pooniwala for judging the final round of arguments this evening. The Moot Court Association shall forever be indebted to you for your continued support and dedication to all our achievements. I would like to thank all the members of the legal fraternity for sparing their valuable time in judging all rounds of the competition. We would like to express our gratitude especially to the judges of the semi-final rounds, Mr. Harish Jaktiani, Mr. Janak Dwarkadas, Mr. Tushar Cooper, Mr. Sharan Jaktiani, Mr. Naushad Engineer, and Mr. Siddharth Mehta. The growth and progress of this Moot Court Association bears testimony to the constant and relentless support of a number of individuals. This prestigious event is truly an outcome of the broad vision of the D.M. Harish Foundation. I would like to take this opportunity to thank all the trustees of the foundation, and in particular, Mr. Anil Harish and Mrs. Shobha Jaktiani for helping in making this competition a grand success. The success of this competition can be attributed to our principal, Dr. Mrs. Asmita Vaidya. Her constant commitment and unconditional support to the Moot Court Association ensures the success of all our endeavors. I would also like to thank Assistant Professor Nuzhat Sheikh for being a source of inspiration and for her continuous encouragement and patronage towards the committee. The continued commitment and support of Professor Kishu Daswani to the Moot Court Association has gone a long way in ensuring our success in all our endeavors. I would like to extend my sincerest gratitude to Mr. Rohan Lavkumar for drafting an intricate and detailed moot compromise for the 26th edition. The advisory board of the Moot Court Association, comprising of Mr. Yash Shiralkar, Ms. Shivangi Adani, and Ms. Madhvi Doshi, have been a constant pillar of support and guidance. Their unyielding dedication to the Moot Court Association is irreplaceable, and I would like to thank them for their immense contribution. My tenure in the Moot Court Association would not be what it was without the efforts of the post holders of my team. I'm sincerely thankful to each and every one of them for their unyielding dedication to the Moot Court Association. I would like to extend my gratitude to the former General Secretaries, Ms. Sakshi Shetty and Ms. Vidala Parze, and the former Assistant General Secretaries, Mr. Rajveer Veera and Ms. Dishri Pakarala as well. This moot would not be possible without the constant support of the entire college administration and staff. In particular, particular, I would like to personally thank Ajit Kaka, Jadav Kaka, Manish Kaka, Prajakta ma'am, Rakhi ma'am, Siddesh sir, and Ganesh sir for their dedication and immense contribution. I would like to take a moment to congratulate all participants for their commendable performance in this edition of the Moot. I truly hope this has been a truly enriching experience for you, and we look forward to hosting you again. To end this valedictory function on a solemn note, I request everyone to rise for the state song and the national anthem.
I request the audience to kindly